Form I-907 denial. Missing this one box will kill your premium processing. The receipt notice never came. An engineer in Dallas had been waiting. His employer had paid $2,805 for premium processing. The attorney had submitted everything, or so everyone believed. The H-1B extension was time-sensitive. His current status was expiring in 11 days, and somewhere inside a USCIS lockbox, his entire case was sitting in a rejection pile. Not because of a legal problem, not because of a background issue, not because anything was wrong with his qualifications, his employer's ability to pay, or his underlying petition. Because one checkbox on Form I-907 had been left blank. One box. That's all it took. And right now, while you're watching this, someone you know may be making the exact same mistake, and they have no idea. The premium processing they paid for is not active. The protection they think they have doesn't exist yet. And if they miss the window to correct it, the consequences will follow them for months. Most people assume the attorney caught it. Most people assume the filing service checked it. Most people assume USCIS will send a notice and ask for a correction. They won't always. That assumption is the trap. Today, you're going to understand exactly what that one box is, why it gets missed, and what happens to your case and your timeline when it does. For a long time now, there had been quiet frustration circulating in immigration law circles, not from USCIS press releases, not from formal policy guidance, just murmurs, that Form I-907 was generating a disproportionate number of rejection notices compared to other USCIS forms. Not denials, rejections. There is a critical difference between the two, and I will explain it fully. But first, understand the environment this form exists in. Form I-907 is the request for premium processing service. It is not a petition. It is not evidence. It is a service request. It tells USCIS, this applicant or this employer is paying extra to have a specific petition adjudicated within a guaranteed time frame. Currently, that time frame is 15 business days for most petition types. Some categories operate on a 30 business day clock. The fee is $2,805 as of early 2025. That is not a small number. And yet, the form that activates this service, the form that tells USCIS to start that clock, is being completed incorrectly at a rate that experienced immigration attorneys describe as alarmingly common. The attorneys who handle high-volume petition work recognize the pattern, the rushed filing, the assumption that the form speaks for itself, the missing selection in Part 2, the section that most people gloss over because it looks optional when it is absolutely not. And when premium processing breaks down, it doesn't send you a warning signal. It just stops working. Earlier this year, USCIS updated its instructions for Form I-907 in ways that compounded the confusion that was already building around this form. What the revised instructions made clearer, though still not clearly enough for many filers, was that Part 2 of the form requires more than just a petitioner's signature and a fee. Part 2 requires the filer to select the specific petition type for which premium processing is being requested. This sounds obvious. It is not. The form lists multiple petition categories: H-1B, L-1A, L-1B, O-1, EB-1, EB-2, NIW, TN, and others. The applicant, or their representative, must actively check the box corresponding to the petition type being filed. Not just attach the I-907 to the petition package, not just include the correct fee, not just sign the form. Select the specific category. Observers in the immigration community weren't always sure whether this was a design problem with the form or a training problem with filers. In practice, it appears to be both. But one thing became increasingly clear. USCIS was not doing petitioners a favor when this box was missed. They were issuing rejection notices and returning the entire package. The rejection notices being issued by USCIS for incomplete I-907 forms are not the kind of notice that leaves room for interpretation. They are direct. They cite the specific deficiency, and they return the entire filing, including the underlying petition, as though it were never submitted. Immigration attorneys who began tracking this pattern described the notices as procedurally correct, financially punishing, and most importantly, timeline destroying for applicants who had built their plans around a premium processing guarantee. Because here is what the rejection actually means in practical terms. Your premium processing fee check or money order is returned. Your underlying petition, the I-129, the I-140, whatever form you filed with the I-907, is also returned. Your filing date is not preserved. Your priority date, if relevant, is not locked in. And in cases where the underlying petition had a time-sensitive status component, like an H-1B worker whose current authorized stay is expiring, the gap between the rejection and the resubmission is not protected time. That gap is exposure. That gap is unlawful presence risk, depending on the circumstances. And for applicants who were relying on the timely adjudication of their petition to maintain continuous work authorization, the gap is also income risk. The attorney in Dallas I mentioned at the beginning of this video, his employer paid for emergency legal services to prepare a rapid resubmission. The engineer had to stop working for a period while the case was reprocessed. The company had to file a new I-907, pay a new fee, restart the clock. What should have taken 15 business days took 3 months, because one box was blank. Let me walk you through exactly what Part 2 of Form I-907 looks like, and where the failure point happens most often. The form is organized into several parts. Part 1 collects petitioner and beneficiary information. Part 3 handles the certification and signature. Part 2 is where the actual premium processing request is made. In Part 2, there is a section that asks the petitioner to indicate the petition type. It lists the classifications eligible for premium processing. Next to each classification is a small checkbox. Most petitioners, and some attorneys, particularly those who file a high volume and work from templates, treat the form as fill in the field only. They complete the name fields, the petition receipt number fields if applicable, the contact information fields, and they sign. The checkbox area is visually adjacent to text that looks like informational content, a list of eligible categories. It does not always register to the eye as a required selection field. It is. And when it isn't checked, USCIS has no obligation to assume which category you meant. They reject. They return. They move on. Now I want to address a question that comes up every time this issue surfaces in immigration forums and legal consultations. Can you just refile? Yes. But it is not as simple as reprinting the form, checking the box, and mailing it again. When an I-907 is rejected, the accompanying petition is also rejected. That means you are not resubmitting a corrected I-907. You are resubmitting your entire petition package with a new I-907, a new filing fee for the petition, and a new premium processing fee. In many employment-based categories, this means you are paying the full cost of the original filing a second time. For an H-1B extension, the I-129 filing fee, the ACWIA training fee if applicable, the fraud prevention and detection fee, the asylum program surcharge, plus another $2,805 for premium processing. Depending on the employer's size and the nature of the petition, a full resubmission can cost between $5,000 and $9,000 before a single dollar of legal fees is counted. And the clock on the beneficiary's authorized stay doesn't pause while you gather that money and prepare the new package. There is a second failure point that I want to identify, because it is slightly different from the blank checkbox issue, but equally damaging. Some filers check the wrong box. This happens when a petitioner is filing, for example, an O-1A visa petition, but checks the H-1B box instead. Or when a petition is being filed under EB-1C, but the form is checked for EB-1A. In some of these cases, USCIS does not reject outright. Instead, they adjudicate the petition under standard processing, not premium, because the category indicated on the I-907 does not match the petition type submitted. The premium processing fee is applied. The case enters standard processing. The petitioner waits 15 business days expecting an approval or denial, and nothing happens. Weeks pass, inquiries are made, and eventually, someone discovers that the processing track selected on the I-907 was misaligned with the underlying case. By this point, the 15-business-day clock has never started. The case is sitting in a standard processing queue with a premium processing receipt attached, generating confusion at every level of the system. Resolving this kind of error requires a service request, a possible inquiry to USCIS, and in some cases a congressional inquiry if the timeline has become critical. This is not a hypothetical scenario. It is documented in attorney practice notes across multiple immigration law firms that handle employer-sponsored petitions. Let me talk about who is most at risk for this specific error, because it is not evenly distributed across all filer types. Self-represented petitioners who file their own I-129 or I-140 with a concurrent I-907 are the highest risk group. USCIS allows this. Many petitioners take this approach to save on legal fees. But the I-907 instructions, while available on the USCIS website, are written in regulatory language that is easy to misread under pressure. The second high-risk group is HR professionals and in-house immigration coordinators at companies that have high petition volume but do not use outside immigration counsel. These coordinators often develop internal checklists based on earlier filings. If those checklists were built before a form revision or before USCIS updated its instructions, the checkbox requirement may not appear on the checklist at all. The third group, and this is the one that surprises people, is applicants represented by attorneys who are not immigration specialists. Business attorneys, estate attorneys, even some general practitioners occasionally handle immigration filings for clients as a courtesy service. They may know the substantive immigration law well enough, but they are not always current on form-level procedural requirements that change without major announcements. Form I-907's checkbox requirement is exactly the kind of operational detail that falls through the gaps in a non-specialist practice. There is one more element of this issue that I want to address directly, because it affects how you should verify your own filing going forward. USCIS does not always catch the missing checkbox before cashing your check. In some documented cases, filers have received a payment receipt, confirmation that USCIS deposited the premium processing fee before the rejection notice arrived. This creates a false sense of security. The receipt notice says your case is being processed, the fee was cleared, the case number was assigned, and then, days or weeks later, a separate notice arrives explaining that the I-907 was deficient and the entire package is being returned. What happened in between? USCIS processes payments at lockbox facilities before substantive review occurs. The lockbox confirms payment and generates a receipt automatically. A different unit then reviews the form for completeness. These are two separate steps in the same system. The receipt does not mean your premium processing is active. The only confirmation that premium processing is active is a specific notice that identifies your petition as accepted for premium processing adjudication within the guaranteed time frame. If you have a receipt notice but have not received that specific premium processing acceptance notice, you need to verify your case status immediately. Here is what you should do right now if you have a pending I-907 attached to any petition. Pull the I-907 that was submitted with your case. If you don't have a copy, your attorney should. If you are self-represented, check your filing records. Go directly to Part 2 of the form. Find the classification selection area. Confirm that the correct box is checked for your specific petition type. If you are unsure which category applies to your petition, The USCIS website's premium processing page lists eligible form types by classification. Match your petition form number and visa category to the list. Then go to your USCIS online account or use the case status tool at uscis.gov to check your current case status. If your status shows accepted with language confirming premium processing, you are in good shape. If your status is ambiguous, stalled, or shows a rejection or return of documents, act immediately. Do not wait for a follow-up notice. Contact your attorney or a qualified immigration representative today. Time is the one resource this error consumes most aggressively. As the processing cycle for these petitions continues, more applicants will discover this issue, some of them at the worst possible moment. But you are watching this now. You know what the error is. You know where it happens on the form. You know who is most at risk and why. And you know the exact steps to verify that your case is protected. Knowing this right now doesn't make you paranoid. It makes you prepared. It means you don't lose $2,805 to a blank checkbox. It means you don't spend 3 months reprocessing a case that should have been done in 3 weeks. It means you protect the work authorization, the status, the timeline that your entire career plan or your family's stability depends on. Share this video with anyone you know who has a pending premium processing case. One conversation could save them thousands of dollars and months of their life. Subscribe to Visa Status Radar for more protection. We protect you with real information. Because in immigration, the small details are never small. They are the whole case.